I call Jan Logie.
Thank you, Mr. Speaker. So I rise to speak at the third reading of the Hurunui Kaikōura Earthquake Recovery Bill, which the Green Party is pleased to be able to support. And I will recognise that we supported this bill on its introduction at first reading to Select Committee. And there was a moment in the Select Committee when we were considering where we were at, and we were not sure whether we would be able to support it through the stages of consideration, because it is such a significant power that is being handed to the executive. But it is really, honestly, with a sense of real relief that we are able to support this legislation. And we feel ourselves accountable to the people in the affected communities and to those other New Zealanders who hold dear the rule of law and the process and the power of decision-making of this Parliament. And we hope that people will look at what happens from this critically and provide feedback at any point where they feel it is going awry. But we do hope that this will be seen as an improvement on the processes that have gone before. And that is the point we have got to with it. I do want to just spend a bit of time, and I do realise that if anybody is in a point in the affected communities of watching this debate, they will just probably be wanting us to shut up and pass it. And I recognise that, but I would just like to spend a few minutes on talking to those other people about exactly or loosely what this bill does. So it enables a minister or ministers together to be able to put in an order in council. And what that is in effect an amendment or an override of a piece of legislation. So that if a community has found that the legislation that we have passed collectively through this Parliament is actually providing a barrier to their ability to respond urgently to the needs of their community, or promote the recovery of their community, then there's the ability for that minister to come up with a distinct solution that is not consistent with the law that was passed in this House. So that is a very, very significant power. But it will need to be for the purpose of response and recovery. And there are specific points in the purpose clause of the Act that gives more detail to that. And it needs to be necessary, desirable, and not broader than required to solve their problem. And this applies to areas that have been that are included in the Act as the Hurunui District, the Kaikōura District, the Marlborough District Council, the Wellington City Council, the Hutt City Council, the Canterbury Regional Council, and the Greater Wellington Regional Council area. So in effect, that's from South Canterbury right up to Masterton are areas that are covered where the minister has the ability within that scope to be able to override legislation to meet their response needs. There was certainly some question about whether Wellington and Greater Wellington should be included in this Act. And it's a very difficult call to make. The Hutt City Council supported this legislation. Conversations I had with Wellington City Council were that they were the Mayor was supporting this legislation and it covering them. Though the Mayor of Hutt City did say that actually at the moment they didn't need it. So it was a bit of a judgment call, but I do recognise that actually in Wellington that there are so many businesses that have been affected by the quakes, and while there hasn't been an interruption to telecommunications or water systems, a lot of buildings are uninhabitable. and people have been put out there. So actually some of the ability to provide relief around filing for tax returns may actually be welcome for those businesses in this area. And that is within the scope of this bill to give them that relief or delay. So on the balance of things, we went with being able to accept the broad geographic area, and we're very pleased that additional geographic areas were not able to be added to this. So when the minister decides that if it crosses different areas, that an order in council is needed, they will talk and they will start talking about what the solution might be. And we've built into the legislation a requirement of, if at all practicable, for that minister or ministers to contact affected people or to notify it publicly, so that people can provide input to help make sure that the view of what the problem is and of what the solutions might be is not too limited. And then that draft order and the reasons that the minister thinks that they're necessary will be sent to a review panel. That review panel will be convened by a retired High Court judge, and the members on that review panel will have specific expertise. Initially, they were going to be representative positions, but now it's on the advice of submissions from Local Government New Zealand. I think there was another submission also supporting that. It has become more based around expertise, including Mataranga Māori and Tikanga Māori, and local government and public administration. So that review panel will also have the ability to get comment from other people, and within a specific time frame they will be required to feed back to the minister and provide advice on any possible improvements to that order. And that advice will need to be made public as well. And then, or simultaneously, the draft order in council goes to the Regs Review Committee of Parliament, which includes most parties. Sadly, at this moment, not the Green Party. So we do hope that in Standing Orders Review that the Green Party is included on Regs Review, so that there can be proper parliamentary oversight of these orders, draft orders and councils that represent the full representation of parties within Parliament, because we do have some good contributions to make representing the people that we do. And so then the Regs Review comments will also obviously be public and will be reported back to Parliament. So, and that then the minister will need to have due regard to those comments back, and they'll be public. And any order in council that is put in place through this process will be time-bound until April 2018, if not finished before that, because it was no longer needed, which does create an impression that councils or people, if they believe there's no longer a need for that override of the legislation, could, I guess, make pleadings to the minister for it to finish early. Except there has been the exception again, Local Government New Zealand through the submission process asked for an extension to that time-bound nature to 2021 for specific provisions around the Local Government Act and ratings requirements, because as from the experience in Canterbury, and when there's massive effect and damage to property, and that ongoing after shocks in particular, that damage can go on, and it can be very hard to do the ratings assessments and get them happening in that time frame. So that seemed to be a sensible change, though we do hope and that it will be kept very much within scope. So that's roughly the outline of what this bill does, and we hope it meets the needs of the balance of checks and powers and the ability to support communities.